Chairman. James Quintero, Texas Public Policy Foundation. Thank you for the opportunity to testify today on this very crucial matter. The interim charge before the committee, of course, seeks to explore the state of transparency in Texas, and as a longtime policy professional as well as a frequent TPIA user, I can tell you that the state of affairs is poor. And for evidence of that, one of the things that I'd like to bring to the committee's attention are two draft documents that I hope to publish here shortly, and I want to stress that they are draft documents, so there may be a little room for improvement with this research. But what I've tried to do in the first one, which is titled Erosion Through Exceptions, Understanding Why the Texas Public Information Act is Weakening, is to examine the TPIA exceptions that exist and how they've grown over time. And if you get far enough through the document, what I've also included is a set of recommendations on exceptions to either eliminate or change in a user-friendly way. The second report, which I've also provided to the committee, is titled Out of Darkness Requiring Publicly Supported Entities to Be Transparent. And with that particular research piece, what I've attempted to do is identify a key deficiency which exists in the law today, and that is that the TPIA does not meaningfully apply to nonprofits, organizations, or institutions that are heavily funded by public monies. These entities simply operate in the dark, and without sunlight, I would strongly suggest that people are not able to really learn about how their tax dollars are being used by these entities through ordinary channels. And so on the basis of these two publications, what I'd like to do is offer up three short observations and followed by a couple of recommendations for the committee's consideration. The first observation is that exceptions represent a big and growing threat to the public's right to know. And to appreciate that point, what I'd like the body to consider is their quantity, quality, and effect. And of course, we've heard it repeated a few different times that the number of open records rulings issued in this year, in terms of quantity, the number of exceptions in the law today totals 75. That is, of course, an increase from the Texas Open Records Act original 16 different exceptions. So we've had a fair amount of growth in the number of exceptions over the last 50 plus years. In terms of quality, I would suggest that the scope of accepted information seems to have grown in ways that are incongruent with the TPIA's opening preamble. And I don't ordinarily do this, but for any interested party who wants to know what the TPIA should do, I would encourage that person to read Chapter 552.001 of the Government Code, because it offers up a very aspirational framework that ought to animate the rest of the law, but unfortunately does not. Now, three of the exceptions that I'd probably cite as being most inconsistent with the opening preamble, just off the top of my head, Section 551.121, confidentiality of certain documents held for historical research, 552.126, confidentiality of name of applicant for superintendent of public school district, 552.131, confidentiality of certain economic development information. I think all of this information ought to be open and publicly accessible at any time. These items and others are, of course, part of a larger list that you might find in Appendix B on pages 18 through 23 of that first document that I provided. Now, in terms of effect, I would suggest that the sweeping number and nature of exceptions has invited conflict into our system. And of course, as has already been mentioned, the number of times that a governmental entity has sought to deny requesters' request via an open records ruling reached 48,706 by 2023. That is up from 31,660 in 2015. So there's been a fairly significant level of growth. In fact, according to my estimate, that's about a 54% growth over a 9-year period in the number of times that local governmental entities in particular have sought to withhold documents and data. I think that signals far too much government secrecy. The second observation I'll quickly offer up is that TPIAs exceptions are being employed in particularly damaging ways. And to illustrate that point, I'd like to briefly highlight a recent TPPF lawsuit. A few years ago, Highland Park ISD discovered that certain employees had been engaged in a long-term kickback scheme to defraud the district of certain cash payments. Upon discovering that particular scheme, what district officials did is they put a stop to it, and they also contracted with a firm, Whitley Penn, to investigate the matter. Our team caught wind of that particular investigation, and in August 2022, TPPF scholars sent a PIA request to the district seeking the factual report only. And unfortunately, district officials denied that request on the grounds that it was covered under an attorney-client privilege. To be fair, the district's position was later affirmed by the Attorney General's office. Upon being denied this report, which of course was created by non-lawyers, the foundation filed a lawsuit against the district seeking legal remedy. And in this context, the district argued that the report qualified for the attorney-client privilege because an attorney was CC'd on the original email that transmitted the report. I think this is a gross misuse of the attorney-client privilege, and it can easily be envisioned to allow a governmental entity to hide embarrassing information. And so I hope that TPPF ultimately prevails in court, but I think there's a larger policy danger here that it would be prudent to address. The third and final observation that I'll offer up is that exceptions are not the only challenge with the law today. There are certain aspects of the TPIA that need clarification and strengthening. Of course, what I'm referring to is the second document that I provided that discusses how numerous nonprofits, associations, and leagues that are funded mostly or entirely by public monies operate in the dark. These publicly supported entities derive substantial revenue from state and local governments through membership dues, contractual arrangements, grants, and other sources. However, no real public information exists detailing their specific revenue streams, the purpose for which these monies are collected and spent, or the public's return on investment. I think that this is a serious deficiency with the law. Now, what do we do about all of this? I've got three ideas for the body's consideration. One, I would encourage policymakers to reduce the number of mandatory and permissive exceptions to better align the law with the opening preamble. If we're going to have a law that affirms that government is the servant and not the master of the people, then I would hope that it would be effectuated in a manner consistent with that principle. Again, a list of possible exceptions to reform or remove may be seen in Appendix B of that first report. The second recommendation that I would encourage the body to consider is to reform the way in which certain exceptions are applied, as with the attorney-client privilege, in order to prevent widespread abuse. In this case in particular, I would encourage you to consider limiting its application to only instances where there is active litigation or the serious threat of active litigation to preempt future problems. And then the third and final recommendation is to add unmistakable clarity to the TPIA so that publicly supported entities that are heavily reliant on public monies be subject to the open government process. And I believe you can do this by amending the definitions in Chapter 552 of the Government Code to encompass nonprofits, associations, and organizations whose operating budget consists of 90% or more of public monies. I thank you for